The Judicial Department.
Section 140. County Court for each county, judge, compensation, commission, removal. There shall be established in each county now existing, or which may be hereafter created, in this state, a court, to be styled the county court, to consist of a judge, who shall be a conservator of the peace, and shall receive such compensation for his services as may be prescribed by law. He shall be commissioned by the governor, and shall vacate his office by removal from the county in which he may have been elected. During the period of the first two constitutions, 1792 to 1850, the justices of the peace collectively formed the county court, which had jurisdiction over probate matters, wills and estates, and generally administered the financial and governmental affairs of the county. The third constitution created the office of county court judge, who constituted the probate court, and the quarterly court, which had jurisdiction over minor civil and criminal matters, and was the presiding member of the Court of Claims, which conducted the financial and governmental business of the county. Section 140 continued the office of county court judge. The judicial amendment of 1975 stripped the county court judge of judicial functions. But that officer continues to preside over the fiscal court, formerly the Court of Claims. Pursuant to this section, the General Assembly has established the maximum salary level for county judges and provided that vacancies in the office are to be filled by the governor. According to the Attorney General, a county judge called to active military duty by the federal government for a period exceeding his or her remaining term of office, in the absence of the intent to abandon that office, has not vacated his civil office within the meaning of Section 140. However, while serving in the military, his or her functions as county judge are suspended, and he or she should appoint a temporary replacement. Section 141 was repealed in 1975. It read at the time of repeal, jurisdiction of county courts.
Section 142. Justices' districts, one justice for each district, jurisdiction and powers of justices, commissions, removal. Each county now existing, or which may hereafter be created, in this state, shall be laid off into districts in such manner as the General Assembly may direct. But no county shall have less than 3 nor more than 8 districts, in each of which districts one justice of the peace shall be elected as provided in Section 99. The General Assembly shall make provisions for regulating the number of said districts from time to time within the limits herein prescribed, and for fixing the boundaries thereof. The jurisdiction of justices of the peace shall be coextensive with the county, and shall be equal and uniform throughout the state. Justices of the peace shall be conservators of the peace. They shall be commissioned by the governor, and shall vacate their offices by removal from the districts, respectively, in which they may have been elected. The third constitution was the first to provide for districts for justices of the peace. This was in response to complaints that some parts of counties had few, if any, of the local magistrates. Section 142 limited the number of districts to 8 and likewise the number of justices of peace because the framers of the current constitution believed there were too many of these local magistrates and that this made local justice too available, an accessibility that encouraged litigation and conflict. The Judicial Amendment of 1975 eliminated the minor civil and criminal judicial powers of the justices of the peace. The amendment also rendered inoperative the provisions in Section 142 that make the magistrates conservators of the peace and that deal with their jurisdiction. In most counties, however, magistrates continue to serve on the fiscal court, although in a minority they have been replaced by county commissioners. According to an opinion of the Attorney General, a statute reapportioning magisterial districts cannot affect current terms of the justices of the peace elected to the fiscal court. The Attorney General has also declared that in counties with a commission form of government, the districts of county commissioners and of the justices of the peace are the same, and therefore the adoption by a county of the commissioner form of government operates to eliminate the justice of the peace districts that exceed the number of commissioner districts. Section 143 was repealed in 1975. It read at the time of its repeal, police court may be established in each city, jurisdiction.
Section 144. Fiscal court for each county, to consist of justices of the peace or commissioners and county judge, quorum. County shall have a fiscal court, which may consist of the judge of the county court and the justices of the peace, in which court the judge of the county court shall preside, if present. Or a county may have 3 commissioners, to be elected from the county at large, who, together with the judge of the county court, shall constitute the fiscal court. A majority of the members of said court shall constitute a court for the transaction of business. But where, for county governmental purposes, a city is by law separated from the remainder of the county, such commissioners may be elected from the part of the county outside of such city. Originally, the justices of the peace of a county collectively constituted the Court of Claims, which handled the financial affairs of a county, including the assessment and collection of county taxes, the settlement of claims against the county, and the construction and maintenance of county buildings and roads. During the period of the Third Constitution, 1851 to 1891, some counties adopted a county commission form of government, substituting county commissioners for justices of the peace on the Court of Claims. Section 144 changed the name of this court to the Fiscal Court and provided that if a county so desired, county commissioners instead of justices of the peace could serve with the county judge as that body. The Kentucky Court of Appeals has held that Section 144 merely creates the fiscal court and provides who shall constitute it, and leaves to the legislature the authority to define the powers of the court. Therefore, a statute establishing the office of county purchasing agent does not unconstitutionally diminish the powers of the fiscal court, in Gross v. Jefferson County Fiscal Court, 1928. An act authorizing the election of county commissioners from each of 3 districts in the county by voters at large also does not violate Section 144, in Hazelrig v. Hazelrig, 1916. The Court of Appeals ruled that a statute enacted to implement Section 144 that established a formula for dividing county expenses between the county government and a city that is separate by law from the rest of the county operates to repeal special legislation enacted prior to the statute for benefit of the city, which it obligates to pay its proportionate share of county expenses, in Richardson v. Bosk, 1901. Section 144 empowers the county judge not only to preside over the fiscal court, but to be counted as a full-fledged member. Therefore, when the judge and 2 others are absent, the presence of the remaining 3 members does not constitute a quorum, when defined as a majority of the membership, in Bath County v. Doherty, 1902.
Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book, The Kentucky State Constitution, by Robert M. Ireland, Oxford University Press.